I'm sure many of you have heard the saying, don't let the fear of striking out keep you from playing the game. Well, I say don't let the fear of lawsuits and litigation keep you from giving your employees the retirement plan they deserve. Let's dive into some of the ways that you can mitigate the risks that lie in your duty as a retirement plan sponsor. Any plan sponsor has a little bit of a fear of litigation, right? It's a hassle first and foremost, but it can also be expensive. So, Sara, give us a case study that best illustrates why fiduciary oversight is so important.
Well, I don't know that there's one specific case. Over the last, since about 2016, we've had 526 cases. We actually had such a huge ramp up in 2020 of over 220 cases that the following years, we didn't have as many, but it's because the law firms that were focused on this already had so much on their docket. It wasn't because it was losing momentum, which at first we looked at, and that was not the case. And as we talked about, we continue to see them do these laundry lists. So even if maybe you're documenting one aspect, you really understand how your contributions and all the administrative aspects are working. If you don't have a good investment policy statement and looking process for your investments, they're gonna hit you in different areas. And just like the Swiss Re, they're gonna have all this laundry list. And if your processes don't document all of it, that case is going to move forward and have that increased litigation.
Right. So give us a few examples of plan sponsors who kind of failed at their duty for prudence and for monitoring their plans properly, and give us some numbers. What are some real financial impacts for those plan sponsors?
Sure. And I want to point out too, again, this is a flawed setup because you just said failed. And that word kind of hits home because I know these plan sponsors. We love our clients in industries all over the country, and they're not doing this from neglect. They're not doing this out of malice. This is just because maybe they don't know. And these legal documents that set up these plans are hard to read. Even for people that do it all the time, not everybody's a trained attorney that can do that. So one of the situations we came across was Danberg versus Lametta. Collision. They were a $9 million plan. I always hear too, hey, we're so small. We're so small, litigation's not going to affect us. $9 million and 114 participants. And they got excessive fee for record keeping and breach of fiduciary duty. And this is one where they were just scrutinized. And the specifics that caused them so much really had to do with the length of time too and the legal expenses. You just don't want to be drawn into this. It just can weigh down. And we're seeing more and more on smaller cases as well. So it's not just those mega cases anymore.
So we see all these headlines, right? And we're talking about all these different examples and all these different cases and the dollars and all of these scary things. So what does a plan sponsor do with that information?
It's kind of like a roadmap. You just have to say, okay, every time you see one of those legal cases come through, see, okay, what did they do wrong? That is now your Cliff Note version of what you need to check in your plan. Excessive fees. Okay, well, I know our record keeper just brought the fees and discussed it with the committee. I know our investment advisor looks at our fees quarterly. Okay, I think I have that checked, but is that listed in the minutes? Okay, let's just go through and do that. And if your job is too busy to go through that, send an email to your advisor. I get emails all the time. Hey, I saw this article. I saw this come up that this is a new suit. Are we doing this? And luckily, because we have structure, discipline, and documentation, more times than not, I can say yes. But you know what? Let's re-review it. Let's use this as part of our next fiduciary training, which is another aspect you can ask your advisor to help you with, is bring these type of lawsuits, explain it, and have that be part of your fiduciary training with your committee.
Yeah, and bringing on an advisor like SWBC, I think it's important plan sponsors know that doesn't require a conversion, right? Going outside of your current record keeper and your current structure doesn't require the pain, right, of doing conversions. But if you need that help and you need to, look at some of these cases and say, I need maybe a little bit of advice around how do I use this productively, there are folks out there like SWBC who can help.
Yes. specifically SWBC, right?
Right, that's right.
But really, not only is it something that, we'd love to help you as an advisor, but if you don't have the expertise, ERISA does say that you're responsible to do that. And they do continue to go forward and say you then have to monitor and look at the due diligence. That's hard to say right at the end of the day.
Due diligence.
Due diligence on all of your fiduciaries. And that is one of the things we help our clients do as well. We actually provide them an annual folder that gives all of those different aspects, our services, our insurance that backs everything that we're able to do, all of those different components that they need to build out their compliance file.
That's right. So if a plan sponsor could implement just one risk mitigation strategy today, what would it be?
Well, that's an interesting thing to ask. There's not just one thing. And I think that's what these suits are saying. You can't just focus on one thing. You really have to go through the whole process. And that's why you need that, again, structure, discipline, and documentation. I feel like we could have a drinking game at this point, but it's so important because you leave yourself vulnerable, right? You can, if you go out and do if you're building a house and you do all the safety things and are building the right thing, but the person that's building your house forgets to put on their hard hat and gets hurt, you've got to cover your bases and make sure that you're protected in every different angle and every way.
So, even just staying away from strictly the fear of litigation, how does a plan sponsor keep up with all of the changing industry trends and changing regulations? 408B2 came out years ago. Then we had Secure Act. Then we had Secure 2.0, which was huge and lots of different provisions. So how do they keep up?
And they were even whispering about Secure 3.0. I'm like, we haven't even gotten halfway through Secure 2.0. You keep up with your advisor and your record keeper. Those are really things. You have hired these professionals to bring you this information and to keep you up to date and compliant. That is their job. And you can ask them to do that job for you. Really, there are so many things as a fiduciary that you can say, I need you to handle this for me. I need you to set up these agendas. I need you to bring this information to me to make sure that my committee is compliant every time we meet.
And I'll say shameless plug for SWBC. It's the no conflicts of interest and getting a full fiduciary commitment, right? It's something we've always done, and we've talked about checklists and different things. Whether it's SWBC or someone else, I think it's important that plan sponsors know those points, right? Get the fiduciary commitment, make sure you get rid of those conflicts of interest.